request you to switch off the, yeah.
Very
So,
well.
yeah.
Great. So I'll just do a brief intro and then we can.
Yeah. So once again, good morning, everyone, and thank you and for joining this webinar on Consumer Protection Act. I am Saharsh Zamani, CEO FADA, and I welcome all of you on behalf of FADA. With me, we have Mr. Amar Jatin Sheth. He is the Treasurer FADA. We have our Speaker of the Day, Mr. Anand Shankar Jha. We have Richa from the Secretariat team. I will now request Amar Bhai to kindly share his opening remarks. Amar Bhai, over to you.
Thank you, sir. Thank you everyone for joining. Sorry, we took a little bit to get settled. Even after so many years now of the digital presence, sometimes there is still a little hiccup. So glad on a Saturday morning you all are here. So this is a part of our endeavor to impart more knowledge and keep our dealer fraternity up to date with what's happening in the country in various chapters. Today we are going to do a session with Mr. Anand Jha, who is the advocate on record for the Supreme Court of India. And it's on the Consumer Protection Act, which is having a lot of changes already come in. Apart from this, we are going to be doing webinars in time on issues which face our dealer community, where we feel we should have more knowledge on. It will be on the subjects which are not limited to, but including GST, including labor laws, CMVR, which is currently also undergoing a lot of change. So we will continuously do these webinar series going forward. If there are any suggestions on any particular topics that you would want to know more about, please do write to us and we will make sure that we incorporate that soon. So let's, on today's seminar, it is on the Consumer Protection Act. And like I mentioned, we have Mr. Anand Jha, who is the advocate on record at the Supreme Court of India. He's an expert in the field of consumer protection. He has a wealth of experience and knowledge in this, and we are very grateful, Mr. Jha, that you spent time today morning to be with us. Mr. Jha has actually spoken to us earlier also through a webinar a few years back when the act was just introduced and getting into action. At that time also his guidance helped us make a few changes in the way we operate and become more compliant. But now, since it is some while that this has already been in force, there are a lot of things that we need to understand from the experience of this being in force. So as professionals in the auto industry, not only are we responsible for delivering a quality product and service to our customers, but also to understand the customer rights, to safeguard them and to ensure their satisfaction. So this Consumer Protection Act is a vital piece of legislation that actually aims to protect and promote the interest of a consumer by establishing a fair and transparent marketplace. So auto dealers, like we all know, sit right in the middle between the manufacturer and the consumer, and a lot of transactions happen both ways for us. A lot of interactions happen both ways for us. We do a lot of activities. So we need to ensure that we are compliant to this act and we have a full understanding of what the impact of this act is. So we hope with today's webinar, Mr. Jha's insights will give us practical guidelines, share best practices on complying with this Consumer Protection Act. And we will also delve into the do's and don'ts for us so that we can improve the way we do business and also protect ourselves from potential risks that can come upon us. Of course, we auto dealers are consumer centric. Our businesses are built that way. But what are the things that we need to take cognizance of, I think is very important to understand. So today we will dwell on two most crucial topics. One is the potential risk and liabilities in case of a product, with Mr. Jha's in-depth understanding of product liability and potential risks to the auto dealer. He will also discuss strategy to minimize these risks and ensure compliance with this act. We will also talk about the best practices to avoid penalties and consumer litigation, where Mr. Jha again will share his expertise on implementing the effective measures that can help the auto dealers to avoid these penalties, litigations, etc. by non-compliance. So we hope that these topics today will not only ensure compliance, but also enhance our trust and loyalty with the customer, because that is finally what we all strive for, and that is the true success that we would as dealers want. So the landscape of our country in the regulation field is changing drastically. We certainly need to keep up to date on it. And this Consumer Protection Act is not just a set of legal requirements, but it is also our commitment to the customers, that we will always prioritize their need. We will always be there with them, respect their rights, and strive to deliver an exceptional experience. So let's get started with this session. We will take questions in the Q&A box and address them later. Do participate, do ask, and I think I'll with this hand it over to Mr. Jha to share his immense experience with all of us.
Thank you, Mr. Sheth. Thank you, Richa, and thank you, Saharsh. This is my second opportunity to be amongst all of you and to speak about a topic that is very close to our heart. That is something that we practice on a day-to-day basis, and a piece of legislation which is gaining more and more importance with every passing day, with every passing month. And the federation of which you all are part of is very, very interconnected to the requirements, to the standards that this piece of legislation, which is the Consumer Protection Act, expects you to comply with, expects you to carry out in your day-to-day activities. So all the friends who have joined today, I can see about 135 members have joined today. Something that is very basic and very fundamental is that in the field of civil law, Consumer Protection Act is one such legislation which is the most regularly applicable, which is something which has maximum impact in our day-to-day functioning. It is basically a set of rights and duties for the consumers, and it sets out certain standards which service providers or manufacturers must adhere to in order to ensure that the products that they deliver meet the standards that are promised. They are not deficient in any manner. The process of sale and service does not entail any element of what is called an unfair trade practice. And the standard which is promised is adhered. And therefore, a new section is added by virtue of what is called as product liability. There are a lot of doubts also, which I could get in form of question and answers, which were circulated to me in advance. And as we have seen in last roughly about 3.5 years since this new legislation came, is that people have not really, and this I'm talking about from the consumer side of it, people have not really understood what are their rights, and similarly, the service providers have not fully understood that what are their responsibilities under this new legislation. So I thought a good way to start this discussion would be that let us first understand the structure of this new legislation. Let us understand how it is different, in which ways is it different from the existing legislation, and what are the specific insertions. I'm here going to talk a little about product liability. I'm going to talk about unfair trade practices, which is something which we must be well aware of as dealers, as the service providers. So let's begin with this short presentation, and then we will come to discuss your questions. Okay. Next. All right. So as I said, this is one subject which has maximum impact in our day-to-day lives in the field of civil law. For a very simple reason is that there are very few subjects where you would feel that people actually take effort to go to a court to have their rights vindicated. And the manner in which this legislation is prepared, it is essentially to aid all those people to approach the courts in a cost-effective manner to seek a vindication of their rights, to seek redressal of, as we call, their grievances. Now, this new legislation has provided a set of changes. And these new changes, you can see that we will provide you a brief comparative analysis of the old Act, which is the Act of 1986, and the new Act, which is the Act of 2019. There are some new bodies which have been established. One is called the Consumer Protection Council. This is the Central Consumer Protection Council, and the Central Consumer Protection Authority, which has been established under this new legislation. This new legislation also provides for a more simplified dispute resolution process, and it also focuses on introduction of ADR methods. ADR is alternate dispute resolution methods, and more specifically, the method which is going to be discussed is the method of mediation. And last, and something which is of great importance to us, is the introduction of chapter on product liability. So I would urge all of you to just download a copy of Consumer Protection Act. It's a simple piece of legislation, but I would request you all to pay some attention to what is called Chapter 6 of this new 2019 Act, which talks about the product liability, okay, and unfair contracts. Let's go to the next slide. So one is the jurisdictional challenge, which has jurisdictional change, which has taken place. Earlier, the three-tier system that we have, one is district forum or district consumer forum, and then every state has a state commission, and all those matters at the state commission can be challenged by way of a revision petition or by way of a first appeal before what is called a national commission. It is a short form for National Consumer Dispute Redressal Commission. So, as you all understand, there are issues pertaining to territorial and issues pertaining to pecuniary jurisdiction. So, under the earlier legislation, as you can see on the left-hand side, it is the district forums which could entertain disputes where the total sum in dispute or the total amount claimed was within 20 lakh rupees. From 20 lakh to 1 crore, the matters straight away went to the state commission, and from 1 crore and above, the matters went to the national commission straight away. So rarely one would find, unless it's a case of a airbag non-deployment or a case of a major accident, these matters typically start from the level of district forum or the state commission under the earlier legislations. It is only by way of an appeal or by way of a challenge to the orders by these courts that we see them coming, or we saw them coming to the National Commission. Under the old law and new law, something which is equally very important is, what was the basis to decide that whether I fit into this 20 lakh bracket or 20 lakh to 1 crore bracket or 1 crore to above bracket? Under the erstwhile legislation of 1986, it was the amount, or what is called the sum in dispute, which was claimed. So let's say if somebody has purchased a vehicle of 15 lakh rupees, but the compensation that he has sought is an amount of rupees 25 lakhs, irrespective of the fact that the vehicle's invoice value or the value on road value of the vehicle was 15 lakh, still the matter would straight away go to state commission. This was under the earlier law. The change which has been brought under this law, the present 2019 Act, is that it is on the basis of actually paid consideration. And that is the criteria for deciding where the matter will actually go for adjudication. So actual paid consideration would leave aside the element of claim. You would have obviously come across several cases since you run such dealerships, is that a person might have a vehicle worth an X amount, but he will claim compensation worth 10x of that amount or 5x of that amount. The present law says we will not look into either the inflated claims or the overall claims under various heads as they are presented. We will only look at the actual paid consideration as the criteria for determining which court would be the first court to address and decide the matter. Now, earlier, there was a 30-day period for appeal against the order of district forum. And earlier, a 50% or 25,000, whichever is less, had to be deposited for filing an appeal. Now, this is something which is not a very good news for all of us, for those who represent the dealers and and it is decided that the manufacturer shall replace the vehicle or shall refund the full value of the vehicle. Earlier, when we had to file an appeal from the District Forum Ernakulam to, let's say, the State Commission at Kochi or State Commission at Trivandrum, we had to deposit either 50% of the overall value or 25,000, whichever is lesser. Okay. So ultimately 25,000 came to be the lesser amount. However, under the present legislation, this has been changed and this has been made to be a 50% of the awarded amount, which makes it very onerous for people who want to challenge, which makes it more and more difficult for dealers, for manufacturers, for service providers, because there's an element of a good amount of value, good amount of money getting stuck in the system. As you understand, the appeals take their own sweet time. Sometimes they go beyond 1 year or 2 years as well. The money, it is widely perceived, is going to remain stuck in the court system. It is going to remain stuck in the registry. However, the reverse side of the logic, the reason why this introduction or this change was inserted was because it was felt that this will reduce the tendency of service providers to challenge the orders before an appellate court. And mind you, it is Consumer Protection Act. So obviously the focus is going to be towards the protection of rights and redressal of grievances of the consumer. When a consumer has to challenge, he need not deposit anything. The deposit criteria of 50% is only when the lower court has directed an X amount to be paid. If, let's say, a lower court, a state commission at Jaipur decides that there is no manufacturing defect, or in servicing of the vehicle, there was no issue, and so zero amount is payable, the complaint is dismissed. But the complainant wants to now challenge it before a higher court. He need not deposit anything. So that is one bit of uneven circumstance that is there. And the last and very important thing, which is in the earlier legislation, which is the 1986 Act, there was no provision for review of the orders of District Forum. Okay. Now, review, as it's commonly known as legal terms, is a method wherein you go to court or you approach a court for correcting what is an apparent error, what is not an error in the details of the case, but which is a very apparent error. For example, instead of rupee, a dollar amount is mentioned, or instead of mg or ml is mentioned, things which are very apparent, which are fundamentally on the face of it look to be erroneous. Earlier, there was no provision for that correction before the same court. And we have had matters where a dealer got late in filing a response. I've had friends who are from, say, Bhopal, who wanted to file a response to a matter which got filed against them, say, at Gwalior. And they got delayed in filing that response by 5 days, by 15 days, by 20, 30 days. And their rights were closed, and against which we had to approach the appellate court, which was the State Commission. Now, that has a serious cost implication for a very simple reason that you need to engage a lawyer in a different city. You need to send him all the papers. He needs to file a case. Now, that has been corrected under the new legislation, where the same court has the power to exercise what is called the right of review. Now, the present legislation has also forayed in some new areas which are of interest, which are of importance with the manner in which the trade and commerce has proliferated in last few decades. One is extension in the area of e-commerce. Introduction of powers to declare a contract as null and void. You see, earlier such powers did not exist, but now the consumer forums also exercise a power where they can declare a contract to be null and to be void and to be unfair in nature. With this, a very vast amount of authority is now vested with the consumer forums. Over the period of time, we have seen that the courts usually decides matters on a factor called sympathy, on a factor called, because if the consumer is complaining, there must be something right about it. Now, that aspect has to be seen over a period of time, that whether courts are really able to balance in terms of sympathy towards the consumer and the documentary record which the party is able to place. This is a brief comparative analysis, the brief things which are of your relevance, which have changed in the present legislation. Let's go to the next slide to see about this new authority which has been constituted under this new legislation. It is called Central Consumer Protection Authority. Mind you, it's an authority which has now come with very vast powers. You all must have heard, and at least those who are in the regulatory space must have heard of a body called Competition Commission of India. Competition Commission of India was a body which was constituted in year 2002, which not only adjudicates, which not only decides the disputes, but which also had a wing called the Director General of Investigations, who could investigate the complaints. Now, on similar lines, even the consumer legislation has added this authority called CCPA, Central Consumer Protection Authority. Chapter 3 of this new law discusses what are the rights, what are the areas in which this authority can function. So the first is, for example, it can conduct investigation into the violations of consumer rights and institute complaints and prosecutions. It has the power of search as well as seizure. So they can, like any other authority, carry out searches which consumer courts could not do. It can carry out searches, it can carry out seizure. So essentially, CCPA was like an investigative arm or an arm, executive arm of the consumer legislation, which not only decides. Earlier, when a consumer had an issue, he could approach the court and court would decide his case. But now if there is a larger issue, for example, there is a larger issue about improper declaration on the food products, or there is a larger issue of, say there was one complaint which was there against the timeshare bodies which provide holiday services, that although they enroll you as a member, but they don't really grant you the benefit, or they charge you even after you become a member. So these larger issues which impact the interest of consumers at large, they can be gone into by the Central Consumer Protection Authority. If I give you, for example, if let's say somebody lodges a complaint in CCPA saying all the dealer friends, all the dealers across the country who deal with in sale of or service of vehicles, they levy what is called handling charge, or they levy something called as a miscellaneous charge in order to cover up whatever expenses that they incur. You please investigate this aspect and see if this is fair, this is justified, and this is as per the Consumer Protection Act or not. That investigation, because it deals with all the consumers across the country, can be carried out by a body called CCPA. Now, going further, it also has the power to order for discontinuation of what it considers unfair trade practice, and it can direct a particular body to stop the advertisements or what is called the misleading advertisements. It has what is called some very vast powers in terms of imposition of penalties on manufacturers, on endorsers. Now, kindly see, this is not only on the manufacturers, this is also on people who endorse such advertisements and publishers of what is called misleading advertisements. Now, this amounts to a very vast power being conferred in the hands of CCPA, wherein it can not only, you would have seen that the film stars are endorsing a particular product which may not be very good for human health. Then they have the authority, CCPA has the authority to even direct that the endorsers of such product, not just the manufacturers, can also be stopped from participating in such advertisements or such misleading advertisements as it is called. And the orders of CCPA can only be challenged before what is called the National Consumer Dispute Redressal Commission, which is also called the National Commission, within 30 days. So there they don't have to go through the rigmarole of district forum, state commission, national commission. CCPA's orders directly come to be challenged before the National Commission. With this, let us go ahead with the next slide, which talks about the simplified dispute resolution process. Now, the reason why the 1986 Act was sought to be amended, one of the important reasons was it was felt that although the intentions of the legislation were very noble, although the timelines which were fixed under the legislation were quite strict, they were not adhered in letter and they were not adhered in spirit. And therefore, in order to make these authorities more accountable, it was felt that let us simplify the process of dispute resolution. So first was, and something this is of importance and this is of interest to all of you, a very important amendment which was inserted was with respect to the jurisdiction. Okay. Earlier, a complaint could be filed at a place where either the defendant resides or the respondent resides, or at a place where the cause of action has arisen. So like somebody gave me a question to say that I have sold the vehicle at Jodhpur. The customer lives at Jaipur, or let's say the customer lives at Delhi. Can he sue me in a court at Delhi? Earlier, under the earlier legislation, the complaint had to be filed either at the place where the defendants reside. So defendant is going to be the dealer, is going to be the manufacturer, or the place where the cause of action has arisen. So if the allegation is that there is a manufacturing defect, then the complaint could be filed at the place where the vehicle was sold, which has now undergone a sea change under the present legislation, in which it is said that a complaint can even be filed at a place where the consumer resides. So let me give you an example, and this is a real life example. An army officer purchases a house while being in service at Mohali, and he is presently posted at, say, Trivandrum. He can file a case at Trivandrum, and the Trivandrum court will be required to adjudicate that dispute. They will issue the notice to that builder or real estate developer at Mohali. Now, kindly see the tragedy of this entire exercise. While the intentions were very good, that a consumer should be able to ventilate, should be able to raise its grievance at a place which is closer to him. Kindly see the reverse impact of that. That builder who's based in Mohali, who has never even gone to Kerala in his entire life, will have to first of all go all the way there, will have to engage a lawyer, file his response within 30 days or 45 days as it is provided under the law. If he does not file his response within that 30 or 45 days period, then his rights are going to be closed and the matter is going to be decided ex parte against him. Now, this is a big loophole in the law, which is and which will be exploited in all times to come, where consumers who want to trouble the service providers will take them to their own home turf and will take them to remote places where they may not have much of presence. Now, let's also look at how the legislation has tried to simplify the process. This legislation has made it easy for approaching the Consumer Commission at the place of residence or work of the complainant, which we just discussed. And I also pointed out to you that how this can result in a situation where hardship can be caused to the service provider. There is also a provision of deemed admissibility of the complaint. That is, if a complaint is filed today and the court has not adjudicated, has not decided whether that complaint is to be admitted, it will be deemed to be admitted within a period of 21 days. Further, there is an empowerment of consumer commissions to enforce its orders. There are more rights being vested. So gone are the days when they would take their own sweet time in issuing, warrants for attachment and so on and so forth. Now imprisonment is provided. Even earlier, the imprisonment was provided. It was very rarely exercised. But under the new legislation, there is a provision for imprisonment in case of non-compliance of orders of District Forum and State Commission. And that's why I always urge all my clients and all my people who seek my views is that please don't sleep over the orders. If you get an order which you either don't agree with or which you think must be challenged, please do that, because the new legislation has provisions regarding imprisonment and which are being enforced as a matter of routine now, which was not the earlier scheme of things. And that's why it's very important that at least you file an appeal well within time. Going forward, as I also mentioned, the state commissions and district commissions also have been vested with what is the power called the power to review their own orders. orders which are fundamentally wrong, orders which have some fundamental mistakes, you need not go to a higher court by way of an appeal. You can go to the same court and also show that, sir, you did not, let's say, there is a finding in one of the orders against one of our members of this association that despite completion of service, you have not returned the vehicle. Okay. And you know that the finding is absolutely wrong. It's completely perverse, because you have written 10 letters to that consumer and he has not come forward to take the vehicle. And the court, or maybe because your lawyer could not point it out, or because the court did not go through the records in full, did not take notice of that. Okay. So then you can, instead of going in an appeal, go in a review before the same court and show that, sir, please see these 5 letters which we have written to the consumer. So it is wrong for you to conclude that we have not returned the vehicle. It is he who has not come forward. So mistakes which are so apparent, which arise purely because the courts have not looked at the records that you have filed in entirety, can be corrected by way of review. And for that, you don't need to file an appeal. Now, appeals only on the question of law after second stage. Now, that is something which is more for the lawyers to understand. And next is state and national commissions have the power to declare the terms of any contract which may be unfair to the consumer or to be null and void. You see, as dealers, we don't have so much to worry insofar as this power of declaring contracts as null and void are concerned. But then there are various other businesses, for example, insurance, for example, banking, for example, real estate, where courts now have clear power. You would have come across a lot of cases where real estate developers have clauses in their contract which says, if you don't pay installments, or if you don't pay the payments on time, we will levy a penalty of 18% of delay compensation on you, which they recover from consumers. But when it comes to them delaying the project, they say we will pay at the rate of 4 rupees per square feet per month, which does not even turn out to be 3% or 4%. So courts do have the power to now declare such uneven clauses, such unbalanced clauses as null and void, as unfair contracts. And therefore, the process of adjudication in a consumer forum becomes more and more important. Under the earlier legislation of 1986, we used to very regularly argue before courts that district forums or state commissions have very limited powers. You can only do so much. You can only grant compensation. But under the new legislation, since the powers have grown so much, and for filing any appeal, you need to deposit 50%. That's why it becomes very important for everyone who is part of such consumer litigations to be vigilant, and at least to be very careful at 3 stages in the matter. We will come to that in the later part of the presentation also, but you need to be very vigilant at the stage number 1. When you file your response to the summons which I issued to you, you need to be very vigilant at the stage when you go for evidence, when you file your evidence. And you need to be equally vigilant when the final arguments take place or the judgment is reserved by any court. Okay. Now with this, let's move ahead to the next slide. This is the ADR, which is the introduction of alternate dispute resolution methods. Now the Consumer Protection Act now provides for settlement of disputes by way of mediation also. And this is a big change. And I would urge all of you to take advantage of this. Although for almost 3.5 years have passed by, all the courts, all the consumer forums and state commissions still don't have the panel of mediators in place. National Commission has such a panel in place. The mediation method basically pushes people, implores them or promotes them that you should go ahead before you file a case, before the matter goes ahead in form of litigation, you should try to resolve. So that has been our advice to most of our clients as well, that if it's not a situation of make or break, or if it is not a case where someone is really trying to hold you for ransom or trying to make across a point which is absolutely baseless, we should take advantage of this mediation. It is, first of all, non-expensive. It's very inexpensive. It's very fast. And thirdly, and very importantly, whatever outcome that you arrive in mediation can be enforced as a court order. So for example, if a customer is not satisfied with your service, or he goes on to make an allegation that there's a serious defect, if not a manufacturing defect in a vehicle or in a scooter, and he files a consumer complaint, as you can understand, even the consumers sometimes don't want to go through the entire hassle of a consumer complaint and the entire process. They want to go for mediation. I would suggest all of you that whoever handles your litigation should, before going for a litigation or before filing the response and the formal procedure ensues, you should definitely explore mediation. And whatever is the outcome of that institutional mediation, please reduce it in writing. Don't make it an oral discussion that I have told you this and you have told me this and we have agreed on this. Because once you agree, mediator's report is presented before the court, and that mediation's report or MOU becomes part of the court order, so that tomorrow, in case the same consumer raises the same problem, you can always show that, sir, at the right stage when he came, we agreed, I have delivered on my promises. Still, this man is in the habit of coming and approaching court on a day-to-day basis. So you should, and we should all explore this. With this, let's go ahead with our next slide. That is the basis of product liability action. Now, as you understand, this is a chapter which is of some importance to all of us. Product liability. You all deal with or deal in sale of a product. Now, in the earlier legislation, which is at the stage of 1986 legislation, always the dealers took a defense, and quite valid defense, that we are not the manufacturer of the vehicle, or we are not the manufacturer of the product that is being sold. And therefore, we cannot be made answerable for the manufacturing issues which are there in the product. But under the new legislation, the scheme of things have slightly changed. So the product liability, if I sum it up in very simple terms, it is a liability for the product that you have sold. So as it was mentioned by Mr. Sheth, that we are committed not only to comply with our obligations under this legislation, but we owe our very existence to the consumers who come and interact with us on a day-to-day basis. It is one of the very inherent promises that a manufacturer makes to a consumer, that the product that I'm selling to you, the product which is going in your hands, is of a particular standard. And the standard may be in terms of its utility, in terms of its safety, in terms of its design. So these standards which are set have to be met. And therefore, a product liability action may be under these major heads, as you can see on the screen, sir. One is the manufacturing defect. We have known it from the times immemorial. Manufacturing defect related complaints have always come. Sometimes even the smallest of grievances are escalated to be called as manufacturing defect. I have done matters where somebody says my horn is not working and that's a manufacturing defect, so please return the vehicle. My scooter light is not blinking properly, so this is a manufacturing defect. You see, there are two definitions which I would urge all of you to have a look at. There is something called as defect, and then there is something called as manufacturing defect. And there is a C difference between both of them, which many a times our courts miss to recognize, that every defect need not be a manufacturing defect. Okay. And the law is now more or less fairly settled that a manufacturing defect is a defect which is so inherent that it makes it impossible for the vehicle to run. So somebody cannot say that, sir, I have run the vehicle for 2 lakh kilometers, but still it has manufacturing defects. You would often come across cases where people make such allegations, and very unfortunate fact is that many courts even accept those submissions, that yes, although the man has run the vehicle for 1.5 lakh kilometers, still there is a possible manufacturing defect. Manufacturing defect is a challenge at the highest level when it comes to a manufacturer. If someone says a Tata vehicle has a manufacturing defect, it is like the capital sentence. It's like the highest order of allegation which is possible against any manufacturer, which cannot be concluded so loosely in absence of what is called an expert report. The other basis of product liability action, as you can see on the screen, is either the design defects or the deviation from the manufacturing specifications. It is also in cases where the express warranty terms are not met. Express warranty terms, as it is contained in the warranty manual, that a product liability action can come. And then failing to contain adequate instructions for correct use. So many a times when the manuals don't provide or the instructions given to the consumer are inadequate, even that can come under the product liability action. Service provided, if it is faulty, if it is imperfect and deficient, even then there can be a product liability action. And this, all of us as dealers must keep in mind, because earlier a product liability or a manufacturing defect action could only happen against the manufacturer. Now, even the service providers are being held answerable in case of faulty or imperfect or deficient services being provided. At this stage, I would like to show you some relevant provision of the Consumer Protection Act. And I would just digress from this presentation, and I'll take you to show Section 82 of the Consumer Protection Act, because that is of importance to all of us to understand that what all is covered under the product liability chapter. And although at present in India, you don't have so many product liability actions, or you don't have a litigation scenario where emission norms are being questioned, or vehicle designs are being questioned, or the service provided is being questioned under the head of product liability. But this is the future. You will find a lot of such cases will come in future. Are we able to show that? Just 1 second. Okay, so this is the chapter, this is chapter 6, which deals with product liability. As I said, the future of consumer litigation, insofar as dealers and manufacturers are concerned, will be in the space of product liability. They will be less in the space of deficiency in service, and they will be more in the space of product liability. So as Section 83 provides, a product liability action may be brought by a complainant against a product manufacturer. So obviously, none of you are product manufacturers, as I understand, but it can also be brought against a product service provider. So in some respects, you are the service provider, or a product seller. We are also sellers, as the case may be, for harm caused. Now, I would urge all of you to take a printout of specifically at least this chapter to understand the scope of the liability. And Section 84 of this Act is of importance. A product manufacturer, although this does not concern us, let us just understand under what heads can he be made liable. So if it's an allegation of manufacturing defect, the product manufacturer will be held liable. If it's a design defect, then the manufacturer will be held liable. If it's a deviation from the manufacturing specifications, then also the manufacturer is liable. And if does not conform to the express warranty, then it is the manufacturer. And item E is there, the product fails to contain adequate instructions. There are several litigations which are now beginning to say that the airbags did not deploy, but your warranty manual did not have sufficient explanation as to under which conditions the airbags would not deploy. But what is of importance to all of us for our discussion today is Section 85 and Section 86. A product service provider shall be liable in a product liability action if the service provided by him was faulty or imperfect. So if someone can tomorrow make an allegation that the service that we provided was faulty or imperfect, or deficient or inadequate in quality, nature, or the manner of performance, which is required to be provided by or under any law for the time being in force, then that amounts to a product liability action against a service provider. When there is an act or omission or negligence or conscious withholding of information. Third, the service provider did not issue adequate instructions or warnings to prevent any harm, and the service did not conform to express warranty or the terms and conditions of the contract. Now, this is a very vast section, and it's a grave area of concern. to all the dealers across the country, to a lot of businesses who feel that, sir, it is not only my actual omission. If the consumer says you did not educate me enough about how to use this particular part of the vehicle, even he can fit that within the definition of this section. If a consumer says I was not properly made aware of the instructions or warnings, then the consumer can bring in an action of product liability. So the provisions are so open-ended that it leaves a lot of scope for misuse. And therefore, not only the warranty manual, but the documentation that you exchange with your customers gain a very vast amount of importance. The structure of your job cards, the structure of your satisfaction notes, the structure of recording of instructions about what all services do they want, and the manner in which we communicate the problems in the vehicle to them gain serious importance. I have told this in a lot of gatherings earlier as well, that gone are the days where you will simply tell a customer that your vehicle has A, B, C problem, and we are going to address that. And you will record that call and you will tell him that, sir, we have carried out this work as per the call discussion that we had. A better method must be evolved. A better method must be evolved by which you record the grievances of the consumer, and more importantly, by which you communicate to him the present shortcomings in the vehicle. So if the vehicle has a clutch problem or a vehicle has a brake pad problem, it must be properly in writing documented that these are the problems which were communicated to him. Yes, I understand there will be logistical challenges. You deal with hundreds and lakhs of thousands of vehicles on a daily basis. How would you do all this? But then the time is gone because of the product liability insertion under the new legislation. The method in which you interact with the consumer has to be more and more documentary in nature and less oral in nature. Next, the service does not conform to the express warranty or terms and conditions of the contract. Now, keeping in mind section 85 subclause D of the new act, we must always, in our job cards, in our satisfaction note, in the bills that we generate as dealers, must clearly disclaim that we do not issue any warranty in respect of the vehicle, or we do not issue any additional warranty in respect of the vehicle or in respect of the services that we have provided. Otherwise, it may fall foul of this section 85D. And now let's look at 86, which is your principal role. That is the product seller. A product seller who's not a manufacturer, obviously all of us are not manufacturers, shall be liable for a product liability action if he has exercised substantial control over designing, testing, manufacturing, packaging, or labeling of product. I think this is of very less importance to us because we are not involved in the process of designing or testing or manufacturing of the vehicle. It is for other products. Let's say someone is selling biscuits or someone is selling some other edible product. Secondly, if he has altered or modified the product, or such alteration or modification was substantial factor in causing the harm. Now, this brings us to a topic which is of great importance to all of us. If there is an alteration that we are carrying out as dealers or modification that we are carrying out as dealers, and if that leads to a harm, you see, if someone has to make an allegation, you will simply say that because you added a guard in front of my vehicle, it met with this particular accident, or the airbags did not deploy, or maybe the vehicle is not giving the relevant amount of mileage as it was promised. Okay. So if they are able to prove that it is because of the alteration that we inserted, then there can be a product liability action. Next is if he has made an express warranty or a product independent of express warranty by the manufacturer. And I hope and I wish that we are not issuing any express warranty over and above the warranty terms which are issued by our manufacturer friends. We as dealers are not adding any warranty, and if we are adding any such warranty, those need to be vetted and those need to be cleared. Next is item E, which is that he has failed to exercise reasonable care in assembling, inspecting, or maintaining the product. Now, this is a very grave area of concern. You please highlight this one. See, the first two lines are very important. He has failed to exercise reasonable care in assembling, inspecting, or maintaining such products. See, maintaining of such product is a very vast area wherein anyone can make any kind of allegation, and this is an open area which will be open for abuse and misuse by all the consumers. And it needs to be seen that how our courts respond to such allegations. Obviously, the more we document, the more we keep our role limited in this process and disclaim all the liabilities that we are not issuing any express warranty. We are only handling the vehicle insofar as it relates to taking the vehicle from the manufacturer and handing over to him. There is no undue intervention at our stage. Then we are clear of this liability, but a lot of potential litigation is likely to come on this head as well. What needs to be also seen, because every rule has an exception, no rule can be made without an exception. We should look at section 87, which is the exceptions to the product liability action. But broadly, these exceptions are available to the manufacturer. And let us look at these exceptions as well. 87.2. In any product liability action, based on failure to provide adequate warnings, instruction, the product manufacturer shall not be liable. Now, this deals with the liability of the product manufacturer, and the exceptions are provided for the product manufacturer. But 87A says a product liability action cannot be brought against the product seller itself if at the time of harm the product was, these three words are going to be of greatest importance to you: misused, altered, or modified. You highlight that 87.1, last three words: misused, altered, or modified. I would urge all of you to keep these three words in mind, because they will form the very edifice of the defense on which we will contest all our matters, all our disputes. If you are able to establish that the problem has arisen because of either misuse or an alteration or a modification, then you are free from any liability as a product seller. Okay. And these three words, every case needs to be brought within the ambit of these three words in order to raise a valid defense. Okay. Now, having seen this relevant provision of the Act, I would like to bring all of you back to the presentation where we were discussing the chapter of product liability. Now, with product liability, there is a new area which has been thrown open, not just for the manufacturers, who are obviously now revising their warranty manuals and the booklets that they issue and the representations that they do, the advertisement, the manner in which they are prepared. But they are also changing the very express warranty terms which are contained, which are held out by them. You need to keep note of the fact that service provided, which is faulty, imperfect, or deficient, has been brought within the purview of product liability action. Now, with this, let us go ahead with the next slide, and we are almost now headed towards the end of this presentation, which is the unfair contract. As I said, now the courts, now the consumer forums also have the power to declare a contract as unfair. A contract between a manufacturer or trader or a consumer will be deemed to be unfair if it causes significant change in rights of consumers, namely requiring the consumer to deposit an excessive security deposit. Okay. So if you take a deposit, if that is found to be an excessive deposit in nature, it will be an unfair contract. If it imposes any penalty on consumer for breach of contract. Now, you see, this is something which I don't personally agree with. If a consumer has, let's say, paid an X amount towards booking and he does not really turn up, you are fully entitled to forfeit that amount. But forfeiture of the penalty amount is really frowned upon by the Consumer Protection Act. Next is refusing to accept an early repayment of debt that is not relevant for you, allowing unilateral termination of contracts, allowing assignment of contract to the detriment of consumer, and imposing any unreasonable charge. Now I'll pause here for a moment. Handling charges and miscellaneous charges are an area of concern for all of us. It is now provided under this new legislation that imposition of any unreasonable charge amounts to an unfair contract between the parties. But then what is reasonable and what is unreasonable cannot be decided just by looking at it from the perspective of a consumer. What is reasonable also has to be seen from the perspective of a service provider. If something is a legitimate, valid and legally permissible charge, or at least the actual charge which somebody has incurred or a let's say a service provider has incurred, such a charge can never be called an unreasonable charge. And if it is called to be so, such matter deserves to be resisted with all the vigor. And I'm quite confident that the courts will see that if a particular X amount of charge is put, let's say Blinkit is delivering grocery to people, and it is adding a amount of charge for the purpose of delivery of goods. Now, nobody can say that this charge is unreasonable, because that reflects either a part or that reflects the actual charge which is incurred or which is paid towards the delivery partners. But then this charge also varies depending on the weather conditions outside, depending on the time of the year that you are in, depending on whether it is 8 p.m. in the night or 2 o'clock in the morning. So therefore, these charges have to be always seen in the context of the manner in which they are applied and the purpose for which they are applied in order to determine if they are unreasonable. Okay. With this, let's go ahead with the next slide. Okay, Section 2, Subclause 35 of the Consumer Protection Act 2019 is defining product liability. And I would urge all of you, and after this presentation, I will also send you some reading material through FADA, through Ms. Richa. Please have a look at these provisions. I know they might not strike to be of great importance to us right now, but when you face a litigation or when you face an unruly consumer who's unnecessarily threatening, in India, we have this problem of people trying to show their clout or their authority either by their connections or by their understanding, then you should be able to address those issues. So Section 235 of the Act provides that any person can make a claim of product liability against such manufacturer, seller, or service provider for such defective products. Product liability means the responsibility of a product manufacturer or a product seller of any product or service related to product to compensate for any harm caused to the consumer by such defective product. Okay, so more or less these things are commonsensical. It is just that they have now been re-christened, they have now been represented in form of a new legislation under new heads, under the new specifications, under which not just the manufacturer, but also the product seller and the service provider can be held liable. Okay, let's go ahead with this to the next slide. A claim for product liability will be lodged obviously by way of a complaint before the district forum or before the state commission. But they can, as we discussed, the body called CCPA, such a claim can be filed there. We will look at this presentation, go to the next slide. So it's basically summarizing what we read just now. If the product contains a manufacturing defect, defect in design, if there's a deviation from manufacturing specifications or does not conform to the warranty, and if it fails to contain the adequate instructions of correct usage or prevent any harm, any warning regarding improper or incorrect usage. Okay. And Section 84, and we also read 85 and 86 and 87. So all those sections gain some importance. Let's go to the next slide. I think we are now almost headed towards the end of our presentation. We have also seen Section 86. I will leave this slide with my friends at FADA, and they can circulate it. What is important is, as a service provider, these are the various heads in which a service provider can be held liable in a product liability action. Okay, and one which is of importance is he has failed to exercise reasonable care in assembling, in inspecting and maintaining such product. And I foresee that a fair number of litigation, a good number of litigations will approach in this area in future. Okay. Let's go to the next slide. Okay. This is liability as a product service provider. Some of my friends in the chat box have already started raising questions. Somebody has asked about, please explain what is an express warranty. Express warranty is a warranty which you set out in writing in black and white and you give it to somebody. That is called an express warranty. And another friend has asked, what about the extended warranty which is sold by the dealer? So extended warranty sold by the dealer, to be called as an express warranty, first of all, must be in black and white. It should set out what exactly do you warrant. It should set out what are the limitations on that warranty, that what all will not be covered under this warranty, what are the charges for that warranty. And if you are making a substantive difference from the warranty which is provided by the manufacturer, then it must, I would say it must be with the consent of the manufacturer. Okay. Next is, can we get a declaration signed by the customer that he would not use the vehicle before registration and installing high security plate number plate? Okay. Now see, there is a body of law which has come on this issue of running the vehicle without registration or without a registration plate. First of all, Motor Vehicles Act, with a temporary number, of course, you can run the vehicle and it has its own limitation. Running without any registration is something which is not permitted under the Motor Vehicles Act. And there are a number of insurance related judgments which do not cover you for the insurance benefit if you are running without the registration. But you see that the declarations that we sign are good, but they have their own inherent limitations. In India, unlike in, let's say, United States or in the UK, the contracts are not given that much importance, or the undertakings or warranties or affidavits are not really always treated in the letter and spirit. So you may take it from in writing from somebody that you will not do this. He will always find one or two methods to raise that in a legal process that I was not informed. But yes, you can seek a declaration to this effect from a customer that he would obtain the registration and he would ply the vehicle after installation of a number plate. Okay, let's go to the next slide. We will come to the question. Let me just finish the slides and we will come to the questions in just a bit. Product sellers shall be exempted from liability. We saw that what are the exceptions of liability, but what is important is last few, that the product purchased by the employer was used at the workplace and warnings or instructions were provided to the employer. These are all there in section 87. This is exactly the language of section 87. The product sold as a component or material, another product was caused by the end product. The product was legally meant to be used or dispensed by under the supervision of an expert. Complainant while using the product was under the influence of alcohol. That is a very obvious exception that you have. And as I mentioned, these three words are of great importance to all of us as dealers: misuse, alteration, modification. Okay. The way consumers have so many rights, we have some rights which are available and which you should really latch on to. And one such very valid and tenable defense that we have available is under section 87(1). In all your replies, you should definitely mention all of this: misuse, alteration, and modification. Okay, let's go to the next slide of this presentation. Okay, misleading advertisement. You see, that is another area which is of concern, which is the advertising which is happening. Okay, now even the Consumer Protection Act has the power to strike down or to declare any advertisement to be unfair or promising. It's something called as bait advertisement is specified now under the regulations which have come. Let's go to the next slide. So these are defined under section 228. It provides what are the misleading, which gives a false guarantee or which misleads the consumers about the quality or the quantity of the product, or conveying information which would constitute an unfair trade practice, And significant is deliberately concealing any information, any material information. If it is concealed from a consumer, then that falls under the head of misleading advertisement. Okay. Now, under the new legislation, even the pro forma of invoice is specified, that how invoices would be made, what are the essential ingredients of invoice, what the advertisement can and cannot contain, what is going to be called a bait advertisement, what is going to be called a misleading advertisement. So an audit, a broad audit of all the advertisement that you run should be done. Nowadays, even media houses are able to provide for that audit of advertisement so that they do not fall foul of legislation such as legal metrology, Consumer Protection Act. But it is important that we also do that audit before we take out any advertisement in the newspapers. Let's go to the next slide with this. Unfair trade practice. And the Act has listed 6 types of unfair, very clearly known unfair trade practice. And let me tell you, this is not all. This is only a list which is indicative in nature. There can be more and different kinds of unfair trade practices. First is failure or non-issuance of bill or a cash memo. Thereafter is refusal to take back or withdraw a defective good, or withdrawal or discontinuation of a deficient service, or refusal to refund the consideration amount. Third is disclosure of personal information given in confidence, unless required by law or in public interest. Even the disclosure of personal information of consumer now falls within the definition of unfair trade practices. The data protection bill is now on its way to become a legislation. You can expect a legislation to come maybe within a year or two. The privacy related obligations will be higher. Let's go to the next slide with this. Deficiency in service is something which we have known for times immemorial now. It basically means fault, imperfection, shortcoming, or inadequacy in quality and the nature and the manner of performance. The idea is that this legislation, as I mentioned at the very beginning, is something which you will very regularly come across, and it is very commonsensical in nature. And therefore, you can all relate to this, that a definition of deficiency in service would include an act of negligence, omission, or commission which causes loss or injury to any person, and deliberately withholding the information by such persons. Okay, have we finished? Okay, now steps to handle the investigation before CCPA. This I had specifically kept in mind for the manufacturers. It would be very rare that US dealers would have notices from CCPA because it is all India level issues, the issues which impact not just, let's say, the consumers of one dealership or a few dealerships, which will be investigated by CCPA. So if, let's say, there's an emission related standard, or there is an issue regarding gross delay in delivery of a particular type of vehicle, such issues would be more. So usually in consumer matters, dealers are at the forefront of dispute. In CCPA matters, the manufacturers will be at the forefront of the dispute, and you can gladly take a backseat. We will go to the next slide in such of this presentation. This is the structure of CCPA. Let me just broadly show it to you for 30 seconds. That they find a prima facie violation or no prima facie violation. If they find a prima facie violation, a very extensive investigation is carried out by the Office of Director General, or the district collector is also authorized to do so. They have the power of search and seizure, and the appeal against the final order of CCPA lies before the National Commission. And the next slide we have discussed about, what is this? While determining penalty, this is insofar as the CCPA's authority is concerned. This is not in respect of simple disputes between consumer and service providers, which we usually see. Okay. This is something you should see in relation to goods and services, what all they can direct. And this is important. They can direct for recall of goods and withdrawal of goods. Now, this is something very serious. Reimbursement of the price and discontinuation of practices. And these are very generic and very vast directions which can have serious financial implications, reputational implications for the manufacturers. And the next is in relation to misleading advertisements. There can be a direction of 10 lakh penalty, prohibition for making such an advertisement for 1 year, and discontinuation of such advertisement can also be directed. And for a subsequent violation, there are enhanced penalties which are provided of 50 lakh and prohibition. Instead of 1 year, it can be now for a period of 3 years. Okay. So CCPA is a body one should be really careful about. If you get a consumer court notice, maybe you can react after a few hours. But if you get a CCPA notice, react immediately. That is the point. Let's go ahead with the no liability clause. This is in respect of the endorsers. So I doubt that you would be engaging any endorsers. And if you do engage endorsers, under which circumstances there can be no liability of endorsers is provided under this new legislation as well. And 7 best practices to avoid penalty in consumer litigation. Okay. Now we will keep this slide on in front of us and start discussing the questions that we have. And let me have a look at the questions. And service vehicles being left unclaimed by the owners. May I just request Richa, now it's time that you come in, please, and either read out these questions or my friends can ask and then we can respond to them.
Hello. Yeah. So we have a question. Serviced vehicles left being unclaimed by the owner for a longer period, and after numerous notices, he did not turn back to claim. How can enforcing of arbitration?
How can? I missed you there.
Hello.
Yes.
Yeah. So how can enforcing of arbitration 1996 provisions help to settle the claims to the service company? Because filing a civil suit with attachment order is a very time-consuming process.
True, correct. You are absolutely right. You see, first of all, none of us want to go to court. So therefore, in order to invoke the provisions of arbitration, there must be an arbitration clause in your contracts to begin with. So if someone comes and gives you his vehicle, whatever agreement or the document that you sign with him must clearly contain an arbitration clause. It is only then that you will be able to go in the manner of appointment of an arbitrator and seek an award. But before that, let's give a minute to this very serious problem of abandoning the vehicle. Okay. It is something which I have seen and which I have heard across the length and breadth of this country, where people are aggrieved by the fact that an irate customer or a customer who would not submit to reason has simply dumped the vehicle and has gone missing and would not come forward to either pay for the cost of repair or would not either come forward to take the vehicle, by which he is blocking the space in my yard. Okay. There are 2 judgments, and I would want to circulate all of that to all of you, which clearly frown upon this practice of abandoning the vehicle. Okay. And they are of the highest courts of this country. Okay. Now, you see, this abandoning the vehicle is played out in 2 different manners in court. When a consumer reaches there, he says कि साहब इसने मेरी गाड़ी में बोला था कि 5,000 का काम होगा, but उसने 5 लाख का बिल बना दिया और इस वजह से मैं वहां से नहीं ले पाया. ठीक है. Or secondly, they make an allegation that you did not release the vehicle. You see, when the matter reaches court, there is nobody who's recording all of this. There is no police which comes to investigate whose statement is right, whose statement is wrong. So therefore, the procedure or the court has to believe either your word or my word. In such a litigation, I have devised a standard operating procedure for a lot of my clients, wherein we issue at least 3 notices to all of them, all these people. First notices are within a week of the completion of service, wherein they are called upon. And these notices don't go by way of WhatsApp. I know we love to write things quickly by way of WhatsApp and short messages. They will go in form of recorded email or letters, wherein we will intimate them the vehicle is complete. This is the total overall cost. You need to collect this. And in case of any delay, the parking charges will be first 10 days, this rate, 10 days to 30 days, this rate. And the total amount payable as on this date is this. This is the first letter that goes. The second letter goes after a gap of a fortnight, which is 15 days. And even if then the vehicle is not picked up, 30 days thereafter, a final reminder goes. Okay. Now the question is the reason for abandon of this vehicle. These people pop up suddenly when you start taking some action against them. Let's say your dues have become 1 lakh rupees and you go on to recover, then they will file a consumer case against you. If you have an arbitration clause in your contract, you can go ahead to have an expeditious decree, and under that you can go ahead and auction the vehicle. Or the second method is that you go to a court, file an application, get an order for auctioning of the vehicle, auction it, and then set off against your dues. Okay. Now, this is a serious problem which has arisen across the country of abandoning the vehicle. I have done almost 3-4 matters in very recent past where the courts have acknowledged this problem, that people are abandoning their vehicle for a variety of reasons, and this cannot be tolerated. And unless and until such a consumer pays the parking charges in full, or he liquidates all his dues, he cannot be permitted to take the vehicle, and he cannot be permitted to even seek a redressal of his other grievances which he's raising. Okay. So that is one thing we should keep in mind. What else is there, ma'am?
So next question is, can the consumer approach the authority without giving reasonable opportunity for the seller service provided to resolve the dispute?
Yeah, you are right. So it's like this. I gave my vehicle to you first. I had an accident. My airbags did not deploy. The vehicle was towed by the dealership, and he straight away within 1 week goes on to file a case. There are various people who like to threaten dealership, who like to threaten manufacturers or service providers by directly filing a case. Under the law, mind you, there is no such requirement of giving a notice. Okay. The reasonable people, or I would say 90% of the population, usually issues at least one legal notice or a few emails before they actually start the legal process. Okay. But if there is somebody who is directly approaching the court without even giving you an opportunity for correcting the vehicle or for handing over the vehicle within a week or 10 days or 15 days, in such a situation, my request would be this. Number one, there is a new provision for mediation which has come under the new legislation. You, as a matter of right, can explore mediation and get a direction from the court that the other party be made to sit for mediation, at least for the initial sessions. Okay. So explore mediation. Number two, within the 30 days period when your reply is sought, you must take this defense and you must put it in writing before the court that even before granting us an opportunity, he has triggered the legal mechanism and the vehicle is now ready. It is now completely in a fit roadworthy condition to be collected by him. Please give a direction to him to collect. Failing which, your 3 notices, 1 week notice, fortnight notice, and monthly notice must go to him. And a copy of those 3 notices must be placed on record. Okay. So I think you will make some use of mediation procedure for dealing with such customers who reach court at the drop of the hat. What else, ma'am?
Can customer ask us to use different brand of oil with same specification bought by him from market?
Well, I would ideally say, why not? See, the customer has that liberty, but we have our own commercial tie-ups. We have our own commercial understandings. So that is a very tricky area. If I go strictly as per the law, obviously, customer has all possible choice. He can tell you that use X kind of oil, unless and until the warranty conditions specifically mention usage of some things. Okay. Usually they provide for best results, use this. Okay. But if it comes to who holds the final choice, yes, the customer holds. And tomorrow, in case you say that, sorry, if you use a X kind of oil or X company's oil, then only I will service your vehicle. You are opening the gate for a litigation. And most unfortunately, it seems that such a case would not be decided in your favor. Okay. What else?
So how to deal with left out cars in service center with no response or adamant not taking stand by the customer?
The customer is not taking over the vehicle? You mean the abandoned vehicle?
Yes. Yeah,
Issue 3 notices, as I said,
Yeah,
7
same.
days, 15 days, 30 days, and record them, issue them by way of registered letter. I have seen wonderful cases where the customer was 100% wrong. I have seen matters where politicians, where people who are influential, people who come from such background, do throw their weight around and do all of this. I will give you some of the recent cases which have been decided on such issues, wherein it has been held that this practice cannot be accepted, that you will leave the vehicle, because vehicle can be used, misused in various manners. But then you see how you will manage the vehicle best, I don't know. If he has thrown it on your head, usually the man with bigger resources has more responsibility. So dealer obviously has to bear this responsibility. You will have to, maybe as an association, come up with a policy, okay, wherein such vehicle, the handling of such vehicle has to be dealt. Either such vehicles are to be surrendered to the local police authorities, who I'm quite sure that they have their own set of vehicles to be handled, okay, and
Okay.
a comprehensive institutional policy must come. Like I was told at the beginning, that you interact with regulators also, you interact with other bodies also. You have to draw a policy in this regard, that what do we do with such vehicles, and such policy must have the approval of the local authorities. I am myself trying in a lot of ongoing matters to get directions from the highest possible courts, whether that is National Commission or the Supreme Court, that they should make certain observations, that in such cases, the vehicle dealers should be free. I can't clog my vehicle by non-paying, irritating customers who have just dumped their vehicle and walk away. If we get such observations, if we make any positive development there, I will update FADA about such a thing, right?
Yeah.
What else, ma'am?
So even before filing written version, that is within 30 days from the date of receiving complaint from the customer commission, can the service provider file a mediation petition, or what stage shall be effective for filing mediation petition?
Whenever you get the notice, you can request the court to refer the matter to mediation. You have to kindly see chapter 5, which provides that every commission is going to maintain a list of authorized empaneled mediators with every commission. And on the very first instance, you see, whenever you appear for the first time, you will have to make a request for mediation. And let me make it very, very clear. Filing of reply should not be stopped because of mediation. It's like this, that you will file your response within 30 days, for which if you don't adhere, what are the negative consequences of that. But mediation you can still explore. Okay. So file your reply on the same date or even before that. Please make a request to the court to refer the matter to mediation.
Okay.
What else?
So what are the rights we have as a dealer if customer is going live in social media for defaming us to create pressure to get unreasonable benefits?
You see, unfortunately, you will have to live with most of them. We are in a democratic nation. Unless and until someone is really violating your rights, first blush response will be if someone is making an undue or an incorrect allegation, you file a case for defamation. You file a case for defamation, you move the concerned social media body to take down the content. Okay. There are methods for that. YouTube, Vimeo, all these platforms do. Twitter have the rights to take down the content which is defamatory in nature and which is in violation of laws, amounts to violation of your privacy. So you can write to them. If the methods adopted by so-called social media influencers are really far and beyond, you approach the court to take down the content, or you file a suit for injunction. You see, the problem, as all of us would acknowledge, whether lawyers or non-lawyers, is that people don't want to go to court. Okay, for a very simple reason, that why to trigger a process which is not in your control, and it's a lengthy process, as you understand, and it's an expensive process also. But there will be occasions when you will have to take resort to all of that. So if any social media influencer, and I have also come across a number of videos where such vague allegations about the product quality, about how bad other services are being made, because everyone now has a smartphone and everyone can make an account and upload content. please move for taking down the content and use your rights which are available in law. And there is a very valid provision which exists insofar as defamation, whether that's civil defamation or criminal defamation is concerned. Please take advantage of that and please move. And, a message should go out, not just from the manufacturers. We have filed several cases for manufacturers where wild allegations were made against manufacturers that their product has X problem. Let dealers also do that, just to set certain examples. Okay, what else?
So explain again about handling charges.
Handling charges is a very slippery slope. Okay, let me give you an example. Delhi Transport Department had come with a notification several years ago that handling charges cannot be recovered. Okay, now call it by whatever name, handling charges, miscellaneous charges. Okay, the charges have to reflect an actual cost that you have incurred, whether that is for getting the vehicle from point A to point B, for getting the vehicle ready for delivery. Okay, so that handling charge has to be number one, it has to be permitted by the manufacturer. Number two, it should not fall foul of the local transport regulations. You can name it whatever, you can name it miscellaneous charges, and it should be reflective of the actual cost that you have incurred. Okay, so if you are able to do all of these three, we will be able to defend them. But I have seen matters where the manufacturers have given written instructions to dealers that please don't charge this. And still they are being charged, because obviously as dealers, we have our own problems. We have our own expenses to look at. Okay. Now, in such cases, we should be able to show in court that this charge is reflective of the actual cost that we incur. Okay. It's not that we are making profits out of that, or we are earning huge amount of money out of that. It is reflective of our cost. If that is so, then we should be able to defend such charges. What else?
So what will happen to the old cases?
Old cases
This is
will
the
continue.
question.
Old cases will continue. There are provisions under which all the old matters are supposed to continue. All the orders passed under the 1986 legislation are now enforceable under the new legislation.
Okay. So will retrofitment come under Consumer Protection Act?
You will have to explain what is retrofitment.
Yeah.
What is retrofitment? Pardon my lack of understanding of these technical terms.
Yeah, exactly.
Okay, we can park this question for a little.
Yeah.
Later. Go ahead.
Under slide unfair trade practice, what do we mean by disclosure of personal information?
Sorry, come again.
Under slide unfair trade practice, what do we mean by disclosure of personal information?
Yeah, so that, you will not go ahead to sell the information of the customers to a telemarketer. You will not go ahead and sell it to somebody who's, selling a after-sale service.
Okay.
Non-undue disclosure. Say, for example, there will be some disclosure. If someone is taking a loan, you will give the disclosure. You will make disclosures to the transport authority for the purpose of registration. But you will not go ahead to make any commercial usage of information that you have gathered out of a sale that you have conducted. That is what. And this area will be you will have more light thrown on this aspect under the data protection bill. Okay. So the data that you deal of your customers, of their service history, has to be kept confidential with you. Okay. And within your own organization, within your own people. It can't be sold for commercial gain. That is what it means.
Okay. So there have been cases where customers have claimed they have been sold BS4 vehicles instead of BS6 vehicles, even when they have bought the vehicle with full knowledge. What is the course of action in such cases?
There is a reported judgment of 2022, which has come in this very same issue. Gold Rush dealers, you can Google and find it out. It's a Supreme Court judgment by Justice M.R. Shah, where old vehicle was sold under the name of a new vehicle. But in that case, the dealer could not prove that he had informed the customer that he's going to sell him an X old vehicle. Okay, that's why he was directed to pay compensation. But then if you're selling a vehicle under specific intimation to him, and that intimation can't be oral, let me make it very, very clear. If you are, let's say in 2023, selling a 2021 vehicle or a 2022 vehicle, and you are selling it obviously at some lesser price, or because the customer says the usage are the same, I will get it at a more competitive price. It has to come by way of a written recording. Okay. He has to agree that I am taking a vehicle manufactured in year 2022 or a particular make or model of the vehicle. Okay. Otherwise, you are leaving open a very loose end, which may result into litigation. And this judgment will throw a lot of light about what are your responsibility. Let's say selling of test vehicles, selling of vehicles of old years, of old model and make. This judgment makes it very clear that you will have to inform in advance, okay, not just the essential conditions, the make, type, period of delivery, all of that has to be expressly agreed in writing. Now, what formats we develop for that is for us to get into the nitty-gritties and fine prints of developing those formats. But you will have to do that. I mean, we'll have to learn something from insurance and banking companies in this regard. They may not do a lot of things right, but then still they have everything documented, okay? So we should get more towards that documentary compliance regime. I understand that we are always focused on providing services to the customer so that he's more satisfied. But documentation is one area where we lack usually. Yes, let's go ahead.
Okay, so what is the reasonable amount of handling charge for a two-wheeler which cost around 1 lakh?
I'm a lawyer. How would I know what is
Let's only ask consumer related questions.
Yeah. Let's
Don't
go ahead
with all the questions, please.
Yes.
So whether the relationship between OEM and dealer comes under the ambit of Consumer Protection Act, in this case, whether dealer will be considered as a consumer?
No, dealer is not a consumer to the manufacturer. You see, the consumer's definition has a very valid and very wide exception, which you'll have to understand. A person who avails any service or buys any good for commercial purpose is not a consumer. It's as simple as that. Okay. So for example, if I am buying a vehicle for my company, for my law firm, then I'm not a consumer. But if I'm buying a vehicle for myself, then I'm a consumer. Okay. And the only exception is for self-employment. Let's say if somebody is buying a Tata truck for self-employment, he only has one truck or one pickup vehicle which he uses for earning his livelihood, then he is a consumer. But say dealers don't really do anything for their livelihood. They are doing it as a matter of commerce and trade. And that's why they are not consumers, right?
Yeah. So obligation under warranty is to repair. Can the consumer demand replacement of an aggregate vehicle?
See, all warranty manuals make it very clear that the obligation is to repair what is called a defective part. Okay. But every matter, almost 90% of matters you would come across, ma'am, are the matters where replacement is asked. Everyone wants a new one. If the old one has a horn problem, change my vehicle. Okay. See, one can always demand, but whether he will get, the answer is no. Okay. Unless and until the vehicle has what is called proven manufacturing defect, you are not liable for any replacement. It holds correct for manufacturer. It holds correct for the dealers. Unless and until it has proven manufacturing defect. Okay.
So can the service provider liable for paying compensation for mental agony have been caused due to manufacturing defect by the manufacturer? Can I challenge the district commission order in state commission?
The answer is yes, you can challenge. Insofar as the manufacturing defect related aspects are concerned, the dealers cannot be made liable for payment of either compensation or mental agony. However, it is unfortunate and it is seen very often that किसी के साथ किसी, this is called collateral damage. So once they are penalizing the manufacturer, they will simultaneously also penalize the dealer. Okay. So in such cases, of course you can, and we have successfully in so many matters represented dealers to say that, sir, I am in no manner involved in manufacturing or designing or anything. So please, let me go out of this. And you should definitely challenge such orders.
In case customer wants self-registration, what should be our stand liability? How we can protect ourselves?
I doubt whether such a self-registration is permissible.
Not possible.
It is not possible. It is not
Yeah.
permissible.
I think so. The responsibility of the dealer working through the CMVR comes in, and it doesn't become
Yeah.
a consumer.
Yeah, correct.
Can the OEM compel us to put insurance or genuine oil from them? Can a dealer deny the counter sale of spare parts to a customer? If no, what is the penalty for the dealer?
See, now here we are in the range of your dealer to manufacturer relationship, which is a completely different ball game altogether. Let me tell you. The consumer aspect is you are facing the end consumer of the vehicle. The dealer aspect is this. Now here it's an issue of who enjoys or who exercises how much clout. It completely depends on the kind of documentation they do. If a manufacturer is compelling, there are several remedies to prevent them from doing it. Apart from the commercial remedies or commercial options, there are several manufacturers who have been booked for abuse of dominant position, and the remedy lies before the Competition Commission of India. I'm just talking legally, strictly legal sense. The remedy lies in before the Competition Commission for abuse of dominant position. For spare parts, obviously, they are entitled to tell you that you use the spare parts which are provided by us, or they may give a list of recommended products that you may use. But then it involves an element of compulsion, and when it entails certain negative conditions that if you don't do this, we will not pay you an X amount of incentive, or we will not clear your bills, then it becomes a legal violation. And obviously they can be challenged both by way of an ordinary suit or before the Competition Commission.
Okay. What is the liability of the servicing dealer in cases where complaint arises regarding fetching of a lower mileage than the claimed mileage by the manufacturer?
See, the mileage is a promise, is an express warranty not made by dealer at any point of time. I have hardly come across dealers making such warranties. If they are making warranties regarding the mileage performance, then maybe they can be held liable. But otherwise, it is between the manufacturer and the consumer. You will come across several cases where they will say that in your advertisement, you've said 20 kilometers, it is barely giving me 13 kilometers. That is an issue between the consumer and the OEM. And that is not where the manufacturers can be made liable. Yes, but under the Product Liability Action, as you can see, there's a specific section of Section 85, wherein because of something that you have done, if the mileage has become bad, okay, if the mileage has not really gone up, then they can move an action either for product liability, maybe lesser under that head and more under the head of deficiency in service. But mileage is broadly, as a thumb rule, is a dispute between the OEM and the consumer, right?
Yeah.
Okay.
While dealing a used car transaction, customer has signed all the papers for transferring the car, but doesn't turn up to DTO for the confirmation. What action we can take as a police has denied to file FIR in such cases?
Sorry, come again.
While dealing a used car transaction, customer has signed all the papers for transferring the car, but doesn't turn up to DTO for confirmation. What action we can take as police has denied to file FIR in such cases?
Oh, has he received the money?
That is the question.
No, so if he has not received the money, then see, if you ask me in legal sense, you can have it specifically performed. You can have a mandatory injunction to him to come and get the vehicle registered. But again, the medicine is more expensive than the actual thing. So if that process itself takes you 6 months, then what is the fun left in it? Legal remedy is obviously to have a permanent and mandatory injunction to him. If he has taken money or some part of money, then you can make out a case for cheating and fraud and go ahead with a criminal complaint against him. Obviously, police would not get into an issue like this, but to compel his attendance, either an interim injunction from the court or a full suit for mandatory injunction, or if he has taken some element of money or he has promised something, then you should go ahead to file a criminal complaint against him.
And I guess with the new regulation where the used cars also now come under the ambit of a trade pit of the dealer, these cases in future should not come.
Yes.
Yeah. What steps can be taken if the customer is making false allegation that they were delivered product A instead of product B, even though the customer willingly has bought customer A?
Documentation, documentation, and documentation. I have no other answer to these questions. You see, at the end of the day, 5 years down the line, when parties end up fighting and they reach before the National Commission or Supreme Court, they neither have the benefit of talking to, the dealer, neither the judges know who the customer is. So what you have documented makes all the difference. If you have documented that this person was promised a vehicle of, let's say, 2021, which he took in 2023 with the promise, with the hope that he will get it for lesser price, you are through. And there are several such cases which come. You will find a similar such case was decided by the Supreme Court last year. It was a matter which started from Goa called Tata Motors versus Vaz. Similar dispute reached there. And in all these matters, it becomes very important that you document properly. Okay. And the blanks that you leave are ultimately to be exploited by the consumers. I know as a matter of, it's not that all the consumer grievances are wrong, or most of them are wrong, but I can safely say that 1 out of 3 such grievances are actually exaggeration. Okay. And but then we are not able to show in all the matters. Our documentation is not up to the mark. And that's why we as lawyers for OEMs and many times the lawyers for dealers do feel, and obviously you would understand there's a sympathy element totally in favor of the consumer. So in order to dispel such doubts, we will have to produce documentation. So please maintain proper documentation.
Okay, there may be vehicles which are not in production at present time and reported for repair. Spare parts are also nowhere available. Can we refuse to accept these vehicles by giving a written note if customers demand?
Yeah, you can.
Also, maybe an addition to that, sir, there are certain customers who we do not want to handle at our workshop. Can we refuse to?
In fact, that brings a very important role of authorities like FADA. Like airlines have a no-fly list which is available. Okay. But you don't have don't deal with, banks have a CIBIL score. So similarly, if there are certain known unruly customers who misbehave or who have done this, the information sharing can always be there, wherein you can go ahead and not entertain those customers. But let me tell you, there are always manners in which facts can be twisted. I have seen such complaints happening and people have raised various angles in such complaint. So there should be an institutional policy. So if as a agency or as a federation, you can come out with some broad guidelines that these kind of customers we will not entertain, or beware of this, and then you can internally circulate the list. The only thing is it should not be discriminatory at any point of time. And the person should always have a right to explain himself. Okay. So far as that is there, and you are not the end all and be all of this entire exercise, you can always discourage such people who create nuisance. Create an institutional policy under the aegis of FADA that people who do these kind of, for example, for medical professionals or lawyers, you must have heard recently some legislation came about people who misbehave with doctors. A special law came. Similarly, people who misbehave with lawyers. Okay. Similarly, you as a group of people who face customers on a day-to-day basis, one is obviously the remedy of police complaint. Somebody is causing hurt to you, somebody is being abusive, you can do that. But as an institution, to discourage such people, you should have a policy in place. Let that policy be vetted by people who have some legal understanding, so that tomorrow nobody can challenge that you as an institution are completely throwing me out and without giving me an opportunity. But there should be a policy like this so that such people can be discouraged.
Okay. Can consumer name and photo posted on dealers' social media accounts come under disclosure of personal information? Does the
sorry.
dealer,
Come
sorry,
again?
sir? Yeah, can a consumer name and photo posted on dealer social media accounts come under disclosure of personal information?
No, I
Does
mean,
the dealer,
if the consumer is taking a picture with the manager or the general manager of the dealership with his consent, and the
Yeah.
purpose for which you are putting, the idea is there should not be a commercial exploitation, first of all, and second of all, the element of consent. So if the photograph of a customer is not used for a commercial exploitation, then there's no problem. And if it is happening with his or her consent, then also there's no problem. What else?
what are some basic documentation that we as a dealer should have a return documented by every customer to safeguard ourselves from unnecessary or false allegation in future?
See, you already have a booklet or a docket that you get signed from them. And a lot of dealers have, depending on the dealership of which company that they do, have evolved their own formats. But some of the essential things that need to be recorded, or there should be at least, and it requires a bit of getting into the details about who maintains what sort of clauses. You should, as it is mentioned in this slide, also have a flyer in every docket called most important terms and conditions. Banks have this as a matter of practice. We have developed it for so many banks. It's called MITC, most important terms and conditions. And nobody sees the term and condition mentioned on page number 29 of an insurance policy. Nobody looks at that. Make a one-pager of the most important terms and conditions. Okay. In that, you will provide the make, model, year, okay, price, which are the essential conditions, that the warranty conditions which are provided by the manufacturer are applicable, and that we are not issuing any warranty. So insofar as make, model, price consideration, the manner in which it will work, the service conditions, and the conditions under which you will take care of the vehicle for next 1 lakh kilometer or 1 year period has to be expressly contained in one document. And you will have to see, all of you have to analyze, and if possible, please call for a one page Excel sheet from all your members to compile that at a state level. What kind of litigations are we getting? Okay. See, answers can always be evolved basis our learnings of past. I can tell you from my learnings that if you look at 5 broad categories which lead into litigations, it is number 1, the issues with respect to day-to-day upkeep of the vehicle, delivering a vehicle which was of a different year or different specification, or make some misleading element of advertisement. So once we know all of this, we can contain all those important issues in that one-page flyer and have it admitted. And as some friend also mentioned, have a term regarding Arbitration and Conciliation Act as well, right?
So Richa will now take last 3 questions. If you can just take the Mr. Rajvel, Mr. Manoj Gupta, and Shubham's question. And we will call it a day.
In the earlier era, both the OEM and dealer were jointly held for compensation. What is the present scenario? It is heard that only dealer is made responsible.
No, that's wrong. OEMs are equally made responsible. And in fact, in the present era, with the new litigation, the number of the amount of liability on dealers should reduce. But we have not, unfortunately, seen that happening. The number of matters against dealers have remained the same, which is not a very positive trend. Maybe that is, as I said at the beginning, that is because people have not fully understood this legislation, that how it is different from the earlier one.
Okay, so next question is it mandatory to disclose before selling a new vehicle if any major repair work has been conducted on the vehicle?
Absolutely necessary. Absolutely necessary. We have already given opinion on this count to almost 2 or 3 major OEMs. It is absolutely necessary.
Okay, the last question is, what step we can take if the customer is purposely not satisfied with the vehicle and complaining again and trying to create issue that vehicle is having manufacturing defect, even after OEM is declared that vehicle is okay, after all required diagnosis in return, and customer leave her vehicle in parking of showroom.
Again, so it's a mix of 2 or 3 issues. Number one, are we liable to replace? Number two, the unfortunate abandonment of vehicle, which is very regular. As I said, you or for that reason, the OEM is liable to replace only in case of a proven manufacturing defect, not just a perceived manufacturing defect. Okay. So unless it is proven by a legal process, you are not liable. And insofar as the vehicle lying there, as I said, you devise this method of 7 days, 15 days, and 30 days notices, make them part. And there will be some number of cases which will go for litigation, and which is how lawyers like us thrive. So very good. Let them go there.
That's it, sir.
Thank you
So
very much.
there's last question. Mr. Sameer Chaudhary has asked a question.
What?
Sameer san, if you are there, I'm giving you the rights to speak. Can you ask it?
Hi, my question is very simple. How do we thank you for this wonderful, wonderful webinar? Yeah?
Thank you, Sameer. Thank you.
Thanks so much.
No, I think absolutely it was a great webinar, a lot of learnings. In spite of all of us being in the business for so much time, there are still so many new nuances that we certainly can pick up. I think documentation, like rightly mentioned, we need to keep very proper, and there is no shortcut to that. Those questions about what the model was sold and the year it was sold, about BS4, BS6, if it is properly documented, I don't think the customer will have any case then.
Absolutely right. I'm very sorry to interrupt here. One thing which I wanted to do even the last time, and I think I will put that in practice now, is that every year at least once we will share top 10 judgments which have come in 1 year. I'm sure there's a publication which also happens under the aegis of FADA, right? Some news magazine comes up.
Yes.
We don't need to get into everything. There are going to be hundreds and thousands of cases, but I will list out 10 important judgments which have happened. And if most of your dealers know all of them, I think most of our broad problems get resolved. You don't need to get into everything. So let me take another 2 weeks time to compile those 10. Richa can compile all of them, put it under a link on the website, which all your members can use in future, right?
No, that will be lovely. We actually have a monthly publication that goes out to all our members too physically, and of course on the website too. So we would love to have them on.
Wonderful.
Great.
So
I think we also have a little work to do on maybe make a FADA no-fly list or something like that. So
Make a no-fly list.
so thank you so much, Mr. Jha. It was, I think, extremely insightful and really, really well appreciated. You patiently took all the 47 questions that there were, and
Thank you, so sweet of you. Thank you, Richa, for reading out those questions. And Saharsh, it's always been a pleasure to see you, sir.
thank you, Anandji. Thank you so much. And we'll keep bothering you time and again.
Please do
And
that. Please
like
do
last time, you had written an article for the FADA journal. We'll once again request if an article can come from your desk. It will be great for all other members.
Give us some time. I would like to actually compile this, because the last 2 years have seen some important developments, at least from the Supreme Court. And there are times when we get good orders. You see, bad orders come everywhere in Times of India, Hindustan Times, you will read them everywhere. There are good orders which we've got. Very recently, we've got one very good order, which I had sent to Manishji as well. So at least those good orders should always be. In that matter, the person abandoned the vehicle and ran away. Some member of parliament was using that vehicle and he abandoned the vehicle. He won in all courts and finally he lost here. The court said that you are trying to arm twist them. And see, that is one pain of dealers and OEMs which nobody understands. And we empathize because we see it on a day-to-day basis, that some customers who really go beyond their briefs, and just to arm twist them, they will make all sort of wild allegations, and then it's my word against your word, right? So we'll do this exercise. Thank you very much.
Great. Thank you, everyone. Thank you, Mr. Jha. And we hope all of you had a learning experience. We'll keep doing FADA webinars, keep enlightening you on different topics. Please stay tuned for the next session, which will be coming out soon. Thank you once again.